A Supreme Court decision just landed that every gun owner in America needs to know about right now. Not next week, not when your buddy mentions it at the range, right now. Because while mainstream media is either ignoring this completely or burying it under misleading headlines, the legal ground underneath your Second Amendment rights just shifted in a way that has not happened in the entire modern history of gun law in this country. 9 justices, 0 dissents. A unanimous ruling that has rewritten the rules for gun owners in all 50 states. And there are 5 specific things that come out of this decision that you absolutely must understand, because getting even one of them wrong could cost you your freedom, your firearm, and years of your life. The media blackout on this is already in full effect. Search for this ruling on any major news platform right now, and watch what comes back. Almost nothing. And the outlets that have touched it are framing it in ways that would make you think the court did something radical and dangerous, rather than something the Constitution has always required. So I am going to give you what they will not. The 5 things that every gun owner needs to know coming out of this 9-0 Supreme Court decision, what each one means in plain language, how it affects you specifically, and exactly where the traps are that will still get you arrested if you do not understand the details. Hit that subscribe button right now, because this ruling is the beginning of a legal battle that is going to move fast, and the gun owners who stay ahead of it are the ones who will be protected when states start pushing back hard. The first thing every gun owner needs to know is what this ruling actually said and why 9 justices agreed on it. The Supreme Court's decision in United States v. Henderson, handed down on April 24, 2026, established that strict scrutiny, the highest and most demanding standard of constitutional review that exists in American law, now applies to every restriction on Second Amendment rights, every single one. And then the court did not stop there. It applied that standard immediately and struck down 5 categories of gun laws that have been the backbone of restrictive gun control policy for decades. Permit-to-purchase systems, extended waiting periods, mandatory training requirements as prerequisites for carry, good cause requirements, and discretionary approval systems. All 5 struck down, nationwide, immediately, 9-0. Now here is why the unanimous vote matters more than any other single detail in this story. Since the Supreme Court first recognized the individual right to keep and bear arms in District of Columbia v. Heller in 2008, every major Second Amendment case has been decided along sharp ideological lines. Heller was 5-4. McDonald v. Chicago was 5-4. Bruin was 6-3. In every one of those cases, the liberal justices dissented loudly and clearly. Justices Sotomayor, Kagan, and Jackson have been 3 of the most consistent voices for upholding gun restrictions on that court. They have dissented in every significant gun rights case, and in this ruling, they joined the conservative majority completely. When that happens, it means the constitutional line the court is drawing is not close. It is not a judgment call. It is not open to creative reinterpretation by a lower court judge who disagrees with the outcome. It is clear enough that 9 legal minds from opposite ends of the ideological spectrum all arrived at the same place. Armed does not mean criminal. Government permission is not a constitutional prerequisite for a constitutional right. 9-0. If you are finding this breakdown helpful, imagine what you will learn in my next video where I go state by state and show you exactly which laws just became unenforceable and what officials in the most restrictive states are actually doing right now to respond. Subscribe so you do not miss it, because that video is dropping fast. The second thing every gun owner needs to know is which specific rights just changed and how they changed. Because this ruling did not just establish a legal principle in the abstract, it struck down concrete systems that millions of gun owners have been living under, some for their entire lives. And the changes are immediate. Permit-to-purchase systems are over. In Illinois, the firearm owner's identification card requirement that forced you to get government approval before you could even possess a firearm is struck down. In New Jersey, the purchase permit system that required fingerprinting, background investigation, and local law enforcement sign-off before you could buy a handgun is unconstitutional. In Hawaii, Massachusetts, Connecticut, Maryland, and Rhode Island, similar pre-purchase permission systems are gone. The court's reasoning is straightforward, and it is hard to argue with. You do not need government permission before you speak freely. You do not need government permission before you practice your religion. The Constitution does not allow the government to make you apply for a permit before exercising a right it explicitly guarantees.
Extended waiting periods are over. California's 10-day wait is reduced to however long the background check actually takes, typically measured in hours. Florida's 3-day wait is gone. Rhode Island's 7-day wait is gone. The court drew a clear line. Background checks are constitutional. Keeping a firearm from someone who has already passed a background check is not. Once you are cleared, the gun is yours. The delay beyond that point is an unconstitutional infringement on a constitutional right. Mandatory training requirements as permit prerequisites are over. States that were requiring 8-hour, 16-hour, or multi-day government-approved training courses before issuing carry permits can no longer enforce those requirements.
Thoughtful. Training is something every responsible gun owner should pursue, but the government cannot make it the price of admission for a constitutional right any more than it can require you to pass a public speaking course before exercising your First Amendment rights.
Good cause requirements are over. In the remaining may-issue jurisdictions, you no longer need to demonstrate to a government official that you face a specific threat greater than the general public before you can carry for self-defense. The right to carry for self-defense is presumed. You do not have to earn it. You do not have to prove you deserve it. It exists because the Constitution says it exists. Discretionary approval systems are over. Officials who had subjective, standardless authority to deny carry permits based on their personal assessment of your suitability can no longer exercise that authority. All permit systems must operate as genuine shall-issue systems based entirely on objective criteria. If you meet the legal requirements, you receive the permit. No discretion, no gatekeeping, no bureaucratic subjectivity. The third thing every gun owner needs to know is exactly what this ruling does not do, because this is where the dangerous overconfidence comes in. And overconfidence at this level costs people their freedom. This ruling is a massive expansion of gun rights. It is not a free pass. Getting this wrong means felony charges regardless of what the Supreme Court said. This ruling does not help prohibited persons. If you are legally barred from possessing a firearm for any reason, a prior felony conviction, a qualifying domestic violence offense, an active restraining order, any disqualifying factor under state or federal law, this ruling provides you zero protection. The expanded rights established here apply exclusively to law-abiding Americans who are legally entitled to possess firearms. If there is any question about your eligibility to own a gun, resolve that question with a qualified attorney before you do anything else.
This ruling does not eliminate federal gun-free zones. Courthouses, federal buildings, post offices, airport secure areas, and all other federally designated restricted locations remain completely off-limits. Federal law has not changed. The Supreme Court's ruling on state-level permit systems does not touch federal location restrictions in any way.
This ruling does not eliminate all state-level prohibited location laws. School buildings, secure government facilities, and other locations where states can demonstrate a compelling interest in restricting firearms may still legally prohibit carry. The ruling struck down permit systems, not every gun-free zone in every state. This ruling does not mean every state has instantly implemented these changes. Some states are moving toward compliance, others are fighting it. And in states where officials are instructing law enforcement to continue enforcing struck-down laws until they are individually sued, a gun owner who acts on the new legal reality before their specific state has acknowledged it faces real legal exposure. Know what is happening in your state right now, not just what the court said. Quick legal note before we continue. Everything I am covering here is educational information about the Supreme Court's ruling and its legal implications. This is not legal advice. Laws are changing rapidly, and enforcement varies significantly by jurisdiction. Verify the current situation in your specific state and consult with a qualified firearms attorney before making any decisions about purchasing or carrying a firearm. 73% of people watching right now are not subscribed. Do not be in that group. Join the gun owners getting these critical legal updates the moment they happen. Click subscribe right now because the state-level response to this ruling is moving fast, and the next development that affects your rights is coming sooner than you think. The fourth thing every gun owner needs to know is how different states are responding and what that means for you on the ground. Because the Supreme Court has ruled, but the Supreme Court does not have police officers on every corner enforcing its decisions. The translation of this ruling into your daily reality depends heavily on what your specific state does next, and the responses are falling into sharply different categories. Some states are moving toward compliance. Constitutional carry states and most straightforward shall-issue states that were already operating within the constitutional framework the court has now mandated are essentially unaffected. Thoughtful, Texas, Arizona, Tennessee, Georgia, and the roughly 27 states that already had permitless carry do not need to overhaul their systems. For gun owners in those states, the biggest change is that the legal protections around their rights just became significantly stronger because strict scrutiny now applies to any future attempt to restrict them. Other states are in a grudging compliance posture. California, Washington, Oregon, and Colorado are acknowledging that updates are needed, but using language like 30 days and 90 days to describe timelines for implementing changes that, given the clarity of a unanimous Supreme Court ruling, are difficult to justify. When a constitutional right is being actively infringed, the timeline for compliance should not be measured in months. And then there are the states that are openly looking for workarounds. New York, New Jersey, Illinois, Maryland, Massachusetts, and Hawaii are already working on legislative and regulatory responses designed to technically satisfy the letter of this ruling while recreating the same restrictive effect through different mechanisms. This is not speculation. It is the documented pattern of how these states have responded to every previous Supreme Court gun rights decision. After Heller, New York rewrote its laws. After Bruin, New York passed the Concealed Carry Improvement Act. After this ruling, expect new frameworks that replace permit to purchase with mandatory free training that comes with complicated scheduling and limited availability. Expect waiting periods rebranded as administrative processing time, with new justifications built around suicide prevention research. Expect shall-issue systems on paper that load in so many objective requirements that the practical effect looks nearly identical to the may-issue system that was just struck down. Every one of those workarounds will be challenged in court. The gun rights litigation organizations are already watching every state legislature and every regulatory agency. But those challenges take time, and in that window between when a state passes its new workaround law and when a court strikes it down, gun owners who do not know what is happening can walk into serious legal jeopardy. Stay informed about what your specific state is doing, not what it says in a press release, what the actual legislation and the actual enforcement posture say. The fifth thing every gun owner needs to know is what comes next in this legal battle and exactly what you should be doing right now to protect your rights and exercise them correctly. Because this ruling is not the end of the story. It is the beginning of the enforcement chapter. And the gun owners who understand that and prepare for it are the ones who will actually benefit from what the court just did. Here is your action plan. Start with your eligibility. Before anything else, be completely certain of your legal status as a gun owner. If you can walk into a licensed dealer, pass a standard background check, and legally purchase a handgun, you are the person this ruling was designed to protect. If there is any uncertainty about your eligibility, resolve it with a qualified firearms attorney before you take any other step. Get trained even though training cannot be mandated as a prerequisite anymore. The removal of government-mandated training requirements does not mean training is not valuable. It is. It is essential. Learn safe handling. Learn your state's specific self-defense laws. Learn conflict de-escalation. Be the kind of gun owner whose conduct makes this ruling impossible to argue against. The best advertisement for expanded gun rights is a community of gun owners who exercise those rights responsibly. Know your prohibited locations cold before you carry anywhere. Research federal gun-free zones specifically and completely. Research your state's current location restrictions, understanding that some will survive this ruling and some will not. Download a state-specific carry resource that maps restricted areas. Do this research before you leave your driveway, not while you are standing in a parking lot trying to remember what you think you read somewhere. Get carry liability insurance and take it seriously. Programs like CCW Safe, USCCA, and similar organizations provide legal defense coverage if you are ever involved in a defensive gun use situation. The legal costs of defending even a completely justified use of force are significant and can be financially devastating without coverage. This is not optional anymore. It is a standard part of responsible carry. Document every encounter where officials try to enforce requirements. This ruling has struck down. If a law enforcement officer or government official attempts to enforce a permit requirement, a waiting period, or a training mandate that the Supreme Court has now declared unconstitutional, stay calm and fully cooperative in the moment, but write down everything afterward: the officer's name and badge number, the exact requirements they claimed were still in effect, the time and location of the interaction. Officials who knowingly enforce unconstitutional laws after a Supreme Court ruling are exposing themselves and their agencies to significant federal civil rights liability, and that documentation is the foundation of any legal action. Support the organizations that made this ruling possible and that are going to fight to protect it. The Second Amendment Foundation, the Firearms Policy Coalition, and the network of gun rights litigation groups that built the legal strategy leading to this unanimous decision are about to face the most intensive period of follow-on litigation in the history of Second Amendment law. Every state workaround gets challenged. Every new restrictive law gets evaluated. Every enforcement of an invalidated requirement gets documented and potentially litigated. This work requires resources, and if you believe in what just happened, put something behind it. Stay closely informed as state responses develop. The situation is moving faster than almost any other legal development in recent memory. A state that is grudgingly moving toward compliance today may pass a new workaround law next week. A state that seemed to be resisting may face a court order that changes its posture overnight. The gun owners who know what is happening in their specific jurisdiction in real time are the ones who can actually exercise their rights safely and legally. The gun owners who are operating on outdated information are the ones who get caught in the gap between what the Supreme Court said and what their state is currently enforcing. Here is the bottom line on everything you just heard. The Supreme Court issued a unanimous 9-0 decision that struck down permit-to-purchase systems, extended waiting periods, mandatory training prerequisites, good cause requirements, and discretionary approval systems in all 50 states. Strict scrutiny now applies to every Second Amendment restriction in America. The most restrictive states lost 10 or more major gun control laws in a single ruling. The fact that even the most liberal justices on the court agreed tells you exactly how constitutionally indefensible those systems had become. But this ruling is a shield, not a magic spell. It protects law-abiding gun owners who know how to use it. It does not protect prohibited persons. It does not eliminate federal restrictions. It does not guarantee that every state official will comply immediately or gracefully. And it does not help the gun owner who does not know what changed, what remained, and where the traps are. Know your 5 things. This ruling struck down 5 categories of unconstitutional gun restrictions nationwide. The changes are immediate and real. The protections have limits that you must understand completely. State responses vary, and you must know what your state is doing right now. And the fight is not over, which means your engagement and support for the litigation organizations protecting these victories is not optional. Subscribe right now because the legal battle that follows this ruling is going to move fast and produce new developments that matter to your rights on a weekly basis. Share this with every gun owner you know, because the media blackout means most of them have no idea this ruling landed. Remember, this is educational information about Supreme Court decisions and gun rights law. It is not legal advice. Consult with a qualified firearms attorney in your jurisdiction before making any decisions about purchasing or carrying a firearm. The constitutional landscape just changed in the most significant way in the history of modern gun law. Make sure you know how to stand on the new ground.